This is Captain Mike Hankin of the Marshalltown Police Department. With us today on At Your Service will be Assistant Marshall County Attorneys Paul Crawford and Sarah Tupper and Marshalltown Police Detective Sadie Weekly. Paul, Sarah, and Sadie will be talking with us about the crimes of domestic violence and sexual assault. You'll hear some statistics from Detective Weekly on the number of cases that are investigated and reported to the Marshalltown Police Department. And Paul and Sarah will let you know about the laws that concern both the victim and suspects in these types of investigations.
My name is Sarah Tupper. I'm an Assistant Marshall County Attorney, and I handle the domestic abuse prosecutions in the Marshall County Attorney's Office. When we're talking about a domestic abuse crime, there are a couple of different elements that you have to have in order to have a domestic abuse crime. And the first one is an assault. And an assault can best be described as a physical contact that is offensive or insulting, or it could be the threat of a physical contact that's insulting or offensive. So for example, if someone punches another person in the face, if they shove them, if they stab them with a knife or something of that nature, that would be considered an assault. Then the second thing you have to make it a domestic assault is you have to have a particular relationship between the victim and the defendant. And there are several different ways that you can arrive at that domestic relationship element. One of them is if you have spouses, whether they're living together or not, that's considered a domestic relationship, and an assault between them would be considered a domestic assault. You could have separated or divorced spouses, and that would also qualify as a domestic. Parents of a minor child, someone under the age of 18, would be considered a domestic, whether they reside together or not. You can have individuals who are cohabiting, and what I mean by that is that they are in some sort of romantic relationship. It could be a sexual relationship, but it doesn't have to be, and they reside together. They share income and expenses. They may help each other out with rent and things of that nature, but essentially they have a romantic relationship and they reside together. That would be considered a domestic. And then anyone else who's related by blood or marriage and resides together. So you could have adult siblings who live together, and if one of them assaults the other one, that's considered a domestic. You could have a stepson who assaults his stepfather. If the stepson is over 18, that would be considered a domestic. But a large majority of the cases that I deal with are cases where the parties are married or have a child together or are cohabiting in that romantic relationship, living together. And I think the law is really trying to get at those sorts of relationships, although there are some other relationships that also qualify. In addition, if someone has been in that sort of romantic relationship and resided with someone within the year before the assault, but they're not currently living together, that would also qualify as a domestic. There are several different crimes that you can charge when you're charging a domestic assault crime. The lowest charge you can charge in terms of punishment is a simple misdemeanor domestic abuse assault, which is a domestic assault that's occurred but there hasn't been an injury. And so that is punishable by up to 30 days in jail, and there is a minimum sentence of 2 days in jail for any domestic assault crime. It's also mandatory when someone is convicted of a domestic assault that they have to complete a program called the Iowa Domestic Abuse Program. That's a program that's offered through the Department of Correctional Services, and people take it whether they're on probation or not. It's a 24-week set of classes that is designed to teach people not to be abusive in their intimate relationships. And that's something that is mandatory for any domestic assault conviction. Someone can also be charged with a domestic assault causing injury, which is a serious misdemeanor. The maximum punishment for that is 1 year in jail. And again, it's a 2-day mandatory minimum, which is the mandatory minimum jail sentence for all domestic crimes. Someone can be charged with an aggravated misdemeanor domestic if they use a weapon, if they point a gun at the victim, or they display a knife while they're committing the assault. That would be considered an aggravated misdemeanor. It's also considered an aggravated misdemeanor if there's proof that they intended to cause a serious injury while they committed the domestic. So something much more serious than a bodily injury, something that causes a substantial risk of death or causes permanent disfigurement or something of that nature. If you can show the intent to cause that serious injury, even if the injury doesn't occur, you can charge an aggravated misdemeanor. And there are also different charges if you've had prior domestic assault convictions. If someone is charged with a domestic assault and they have a prior domestic conviction within the last 12 years, then it's considered a second offense and it's subject to increased penalties. It's considered an aggravated misdemeanor if it would have otherwise been a serious misdemeanor. If someone has 2 prior domestic assault convictions and they're within the last 12 years and they're charged with a third domestic, that's considered a Class D felony. The maximum punishment for that charge is 5 years in prison. That is a forcible felony, so if you are convicted of a third offense domestic assault, you have to go to prison. That's mandatory. And that's something the legislature has deemed important. There's a lot of recidivism with domestic assault crimes, and if someone isn't learning from taking that Iowa domestic abuse program class, if they haven't gotten the message from their 2 days in jail that they need to stop this behavior, then the legislature has said, you know what, you need to go to prison for what you've done. There's also a mandatory minimum sentence of 1 year in prison before they're eligible for parole that is associated with that third offense felony domestic. A couple of years ago, the legislature enacted a new domestic assault crime, domestic assault by strangulation. And this is something that we're seeing a lot of in Marshall County and especially in the city of Marshalltown. In the last couple of years that I've been prosecuting here in Marshall County, we've seen a large number of charges of domestic abuse assault by strangulation. And that can be charged when the offender cuts off the air supply or the blood flow around someone's neck or mouth or nose so that they can't breathe or they're not getting the blood that needs to flow through their body to give them life. And if it doesn't cause injury, it's an aggravated misdemeanor, but if it causes injury, it's a Class D felony. Those are the domestic assault crimes. There are other crimes that can be charged in a domestic situation that may not have some of those penalties, such as the Iowa Domestic Abuse Program or the mandatory minimum 2 days in jail, but they still may be appropriate. For example, willful injury would be appropriate in a situation where the offender intended to cause serious injury and actually did cause serious injury. Someone could be charged with attempted murder if the circumstances are correct. So there are certainly other crimes that can also be charged that don't specifically qualify as a domestic abuse assault crime. One of the other things that the legislature has made mandatory in the context of domestic assault is that a no contact order be issued after the offender is arrested for a domestic assault. And that no contact order says that they can't have any contact with the victim of the crime, whether that is in person, whether it is by telephone, by text, by email. They're not allowed to go to the victim's residence, whether the victim is at home or not. They're not allowed to go to the victim's place of work. And again, this is a recognition by the legislature that it's important to protect domestic abuse victims and to keep them safe. Unfortunately, domestic abuse offenders do not always abide by those no contact orders. And in a situation where they do not abide by a no contact order and they violate it, they're subject to some pretty stiff penalties for doing so. If they are found in violation of a no contact order, it's a mandatory minimum sentence of 7 days in jail, which is, again, I think the legislature is saying this is something that you can't do. We want to protect victims, and it's important that you abide by that no contact order. It's also important to note that even if the victim of the offense consents to the no contact order being violated or to the offender having contact with her, it's still considered a violation because it's the court saying to the offender, you cannot have contact with this person. One thing that I think is important to remember in the context of domestic abuse assault is that when you criminalize an act, you're talking about one discrete instance in time. One particular act is deemed a crime. But domestic abuse assault really takes place in a broader context. It is a crime that occurs between people who know each other, especially in the context of spouses or people cohabiting. It's a crime that's committed against someone or by someone that you love. And so it's a lot more difficult for the victim to deal with that sort of crime occurring than it might be to deal with a crime that is committed by a stranger against them. It's also important to note that there are other forces that are at play in that domestic abuse context. So even if an offender is not physically assaulting their victim every day, there are other things that they might be doing. They may be manipulating them. They may be trying to control what they do who they see. Something that's very common in this domestic abuse context is isolation. They try to keep the victim away from friends, family, support mechanisms because they want to control the victim and ensure that the victim is dependent on them so the victim won't leave them. It's very, very common, and this is one of the challenges that I face in prosecuting these cases. It's very common for these pressures that are put upon victims by the offenders for them to decide that they no longer want to participate in prosecution. And some of the pressures that can be placed on them are, besides the isolation and not having contact with family or friends or other people, oftentimes they're financially dependent on the abuser, and so if that no contact order is in place and they're residing on their own, they don't have money to pay for rent, they don't have money to pay for food, their abuser is not giving them that money. They may have children with the abuser, and the abuser may take them to court and try to gain custody of the children, or perhaps they can't afford to go to court themselves, the victim can't, and so the offender keeps the child away from them and they have no way of coming up with the money to go to court and get the child back. So the easiest thing for them to do is just to say, you know what, I don't want to participate in this prosecution anymore. I'm going to do what you want, and I know that's to continue to be with you rather than to leave this relationship. I think it's been shown in studies that one of the most lethal times in a domestic victim's relationship with the offender is when she's trying to leave her abuser. That's when it's most likely that she's going to get hurt or killed. So that's a very serious time in the course of their relationship. On average, a victim will try to leave her offender 7 times before she leaves for good. So because of all those pressures that are at play, and because there are so many reasons that a victim doesn't want to leave, many times she's not willing to participate in the prosecution. And so we have to rely on other forms of evidence in order to prove that an offender is guilty. That's one challenge that we face in domestic abuse prosecutions. The second challenge that we face is similar to what's faced in sex assault prosecutions, and that is what's known as a he said, she said. We often don't have a lot of different kinds of evidence to prove that this crime occurred. Many times it's just one person's word against another's. And as Paul was discussing in the context of sexual assault crimes, many times juries expect there to be forensic evidence and some other type of corroborative evidence, and there often isn't. So it's important to note that one person's word is enough to convict someone of domestic assault if a jury finds that person to be credible and believes what they're saying. But that is a challenge that we face. Something that I would ask that the community as a whole do is to get involved if they know that domestic violence is occurring, report that crime, refer the victim to access for help and for assistance, offer to help them out. But especially if you see a domestic abuse crime, please call the police. Don't be afraid to get involved as a witness, because sometimes that can make the difference between being able to get someone convicted of a domestic abuse crime and not being able to do so. Sometimes because of the pressures that are put on them, because of the fact that the victim ultimately does love her abuser and later on feels bad and doesn't want to see him convicted, not only may she not show up for trial and she may not testify against her abuser, she might show up on his behalf and she might recant and say that the crime didn't even occur, which makes our job in the county attorney's office very, very difficult. So if we can have the community taking a stand and saying this crime is not acceptable, we're going to be a witness in court if we see something happen. We are going to get involved. Then I think that we can hopefully lower the incidence of domestic abuse that happens in our community, or we can at least hold these offenders accountable.
Can you talk about at what point it's out of the accuser's hands and then you guys take over?
Sure. As soon as the police file charges, it's out of the accuser's hands, but probably even a little before that, it's out of the accuser's hands, because police have a duty of mandatory arrest. If they have probable cause to believe that a domestic assault has occurred and there's injury or there's strangulation involved or there's a weapon involved or the intent to cause serious injury, then police have a mandatory duty to arrest. Even if the victim says to them before charges are filed, I don't want you to charge him, they have to go ahead and do it. So from that point on, it's out of the victim's hands. After police file the charges, they go to my office and we're in charge of the prosecution. and the victim cannot come in and say, I want the charges dropped, and be able to have that happen. We certainly have cases where there's a domestic assault charge, and there's also one or more child endangerment charges that are put against the offender because there were children present at the time of a domestic assault, and they witnessed that violence. So that's definitely something as a community that we don't want to see happen.
My name is Paul Crawford. I'm an assistant Marshall County attorney. I've been in the office since 1987. Last decade or so I've been focusing on sexual abuse crimes, the prosecution of those crimes. I guess first of all, best to explain what sexual abuse crimes are. Sex abuse can occur basically a sex act that is done by force, or even if it's not done by force, if it's done against the will of one of the participants, then it can be criminalized. There are various, many crimes that fall under Chapter 709 of the Iowa Code, which is the sexual abuse chapter. The crimes involve both adult victims as well as child victims, can also regulate the counselors, school employees, their conduct with students, and those kind of crimes. So I'm running out of words now, but the punishments for these crimes vary. The most severe crimes are sexual abuse in the first degree, the second degree, and the third degree. It's probably easiest if I start with third degree. That is basically any sex act with another person that involves being done by force or against one of the participants' will. That can be a crime that is what they call a Class C felony, which would be punishable by up to 10 years in prison. And the sex abuse in the second degree also involves a sex act, but it would involve a situation where the victim is a child, that is somebody defined under Iowa law. A child would be someone under 14 years of age. Or it could be a situation where you have multiple people sexually assaulting an individual victim, so a gang rape kind of situation. Those are the situations that are sexual abuse in the second degree. Those crimes are a Class B felony, which in Iowa is a sentence of up to 25 years in prison. And that is also described as a forcible felony, which means that there is no opportunity for the accused person, if they plead guilty or found guilty in a trial, there's no opportunity for that person to get a probation sentence. It is judge has no discretion. The judge must send the person to prison. And the sex abuse in the second degree is also have mandatory minimum punishments to it. That is, the person must spend in prison 70% of that 25 years, which would basically be 17 and a half years, before they could be considered by the parole board for parole eligibility. So it's a pretty lengthy, severe sentence. Sex abuse in the first degree is a Class A felony, which is the equivalent of a kidnapping in the first degree or a murder in the first degree charge in Iowa. That means you could get a lifetime sentence without the possibility of parole. And sex abuse in the first degree is a situation where you would have the sex act occurring, but as a result of that sex act, the person received a serious injury. And a serious injury in Iowa is an injury that causes long-term injury or what was the exact term? Disability, long-term injury, or say a loss of a limb or function of an organ, something to that effect. There are other sex crimes that deal specifically with child victims. They are lascivious acts with a child, indecent contact with a child. The lascivious conduct with a minor. Those have various penalties with them. In probably the last 10 years, Iowa has, in addition to the prison punishments, enacted what they call a special sentence in addition to the prison time. So if a person were to be sentenced to prison, or even if they would get a probation sentence, after that initial sentence is over with, then the Department of Corrections would supervise that person as if they were on a parole status. And that supervision can be either 10 years or it could be for the rest of their life, depending on just how severe the crime is that they're convicted of. So that's I guess was designed as a safeguard so that a sex offender, after they have completed their prison sentence, they wouldn't just be free to roam about and have no contact with a supervisor. So they basically would have to have reporting requirements, subject to polygraph tests, things of that sort that would basically allow checking up on them and their behavior and their residency and things even after they get out of prison. So that's a relatively new punishment that's been added to the punishments for sex offenders. Also, for the last same amount of time, a little bit longer, has been the Iowa Sex Offender Registry. That is likewise, person would be on there for, typically it's a 10-year term, but it would also, depending on the severity of the crime, it could be on the Sex Offender Registry for the rest of their life. And that limits their where they can live. There are, particularly if your victim is a minor or a child, then that's going to not only affect your residency. You can't be within 2,000 feet of living within 2,000 feet of a school or a daycare, places like that. And frankly, looking at the Marshalltown maps, the person's very, very limited of being able to live in the community here with those kind of restrictions. The Sex Offender Registry also has, even if the 2,000-foot law didn't apply to the person, there would be restrictions as to they could not loiter around, say, a park or a library or a school, places like that. They could not have certain jobs, such as a school bus driver, ice cream vendor, supervising or coaching a kids' sporting activity, things of that sort. So those are additional restrictions that the law puts on sex offenders.
So the word you're trying to get across is just don't do it.
Well, yes, unfortunately, in my time here, it's sort of been easier said than done in that regard. We've developed, I think, a very good working relationship with the police department, as well as Access, the counseling and system that here recently used to be known as Marshalltown Domestic Violence Alternative Sexual Assault Center. They merged with an agency out of Ames in Story County called Access, and what they offer is just wonderful in terms of the assisting us both in the law enforcement with the investigation stage. It allows a counselor and a victim advocate to meet with the victim right off the bat if the victim would desire, and so whether it be at the police station or at the hospital, so they can provide some comfort and some counseling to them. And likewise, they help my office tremendously with sort of a bridge between the law enforcement agency and the courtroom. The courtroom can be rather scary for people, adults, as well as children, and so it gives us an opportunity to have a sort of an intermediary or access to the victims and make them feel more comfortable with having that advisor and the victim advocate there with them. the so the courtroom is typically a situation that people are not used to being in. I mean, that's where I live, so to speak. It's either the office or the courtroom, so I'm comfortable with it. But lots of people, it's a scary place to be, and so the advocate helps us out a lot with making people feel comfortable. And with children, the law does allow an opportunity anyway to protect them in the courtroom. There's a provision that says if it looks like the child could be traumatized to the extent of not wanting to talk about things, if they had normally facing their accuser. I mean, the Constitution says you have a right to confront your accuser in court. And so typically that means everybody's in the same courtroom, and even for, say, pretrial depositions, which is like witness interviews, say like would be in a conference room such as here, the accused person could be sitting right across the table from the victim, the child victim. And that can be a pretty scary environment to be in. And so the law does allow us an opportunity, if we can establish that the child would be traumatized by that kind of close quarters. The law does allow the court to provide for basically closed-circuit video interviews of the child at the deposition stage and also the trial stage, so that the offender would not be in the same room as the child and wouldn't be there to just potentially intimidate the child just by their mere presence. Sex abuse crimes are often not made for TV crimes. That is, you see on the TV where someone has been physically injured, or there's been semen left behind, or there's been some sort of a DNA, bodily fluid transfer. In those kind of cases, you see like in CSI that, well, okay, it's there, in the next hour we'll get the DNA analyzed and we'll match it up to a suspect and crime solved and everything. A lot of these sex abuse acts, particularly with children, you can commit a sex act without leaving behind a semen deposit, without transferring bodily fluids. And so a lot of times we're lacking the physical evidence that people see on TV and figure, and some juries have wrongly the attitude that, well, if there's not DNA, then we're not going to convict this person. And it comes down a lot of times to the credibility of the victim versus the credibility of the accused. And because there isn't necessarily physical evidence that's going to be there to support the victim's accusations. A lot of times that is what we have in these situations, and so a lot of times it's an effort to substantiate what the victim is saying in terms of circumstances or things of that sort that can help bolster what the victim is saying, and likewise situations where the accused may say something and then law enforcement can investigate to check out the accuracy of what the accused version of events is. There are ways to support what the victim is saying other than just physical evidence, but our biggest frustration is that folks watch TV and expect to see that there's always going to be physical evidence in a case, and a lot of times there's not. I mean, even if you talk to the nurses at the emergency room, even the trained nurses, the SANE nurses, a sexual assault nurse examiner, they will tell you that in the vast majority of cases where sexual assaults are reported, there's not going to be physical evidence. The emergency room doctors will say that, but trying to get that reality through to the TV viewing juries is sometimes easier said than done.
Right. I'm Detective Sadie Weekly. I work for the Marshalltown Police Department. I'm the domestic violence sexual assault detective. I've been in this position for a little over 5 years, and one of my jobs is to investigate sexual assault crimes, both children and adults. We had 54 cases last year that were investigated by the police department. The majority of those were child sexual assaults, and that was higher than most of the years that we've had, and it's definitely so far higher than what we've had this year to date. We've only had about 12 this year, so we're definitely lower so far this year, which is a good thing. We do realize that a lot of the cases are underreported. There's a national average, they say between about 10 to 28% of sexual assault crimes are actually reported to law enforcement. So obviously that's something we want to work on to try and get those reports up, so we're serving the community as best as we can to get the reports to us. There's another statistic that says every 2 minutes there's a sexual assault crime that's committed in the United States. So we know it's happening. We're just trying to get the people that are having that happen to come forward to us so that we can investigate them. I also work with the sex offender registry here in town. We have approximately 40 to 50 sex offenders at one given time living in town. I know Paul talked earlier about the different residency restrictions that we have, and there's a very small percentage that actually have to abide by the 2,000-foot rule, which is kind of a misconception, I think, to people. Most of the sex offenders we do have here in town can live wherever they want. We have about 5 of those 50 that actually have to abide by the 2,000-foot rule. So it's always a good thing to look at the online registry just to check out things in your neighborhood to make sure that that you are knowledgeable about who's in your neighborhood and where your kids are going and who they are with. We currently have just myself working most of the sex crimes, but we have a lot of investigators and officers that are very well trained that can handle the cases. We work closely with ACCESS, which is our local victim rights advocacy center here in town, which provides services, shelter services for anyone that would need their help going through the process. They can be with them throughout the entire process working with us, whether it's just during an initial interview or if it's during the exam. They can have the advocate there with them for support. And anytime afterwards, if we meet the victim down the road, sometimes it's easier for them to remember things later on than when it first happened. So they can be there for that follow-up interview as well and provide them services throughout the whole process.
I assume there's a time limit for them to report?
There's not. There's a statute of limitations, of course, but we will take a report at any time from them, whether it's something that we can actually prosecute later on the road. Down the road is a different story. That is a matter of, usually it's 10 years after they turn 18 is how long someone could have for an incest situation as a child, or sex first, second, or third degree. They have 10 years after they turn 18 as a child to report that information. But anyway, along the lines, adult or child will be willing to take that report. There's just some statute of limitations as far as how long we can actually prosecute would be the issue, but as much information we can get, especially for intelligence gathering, or if it's a specific offender that may be reoffending, it's going to help us in other cases too. So we always encourage any victim to report that information and let us worry about whether or not it's going to be something that we can prosecute down the road. We have, I think Paul touched earlier, just a lot of people that are worried about not being believed, for one, especially children. I think they don't know who to trust, they don't know who to go to, especially when it's a loved one or a relative that's the one that's perpetrating on them. They don't know who they can go to. So they don't think they're going to be believed, they don't know who they can trust. They're afraid. Even if an adult victim, they might be afraid of their perpetrator. They don't know what's going to happen. Something could happen worse. They don't want to have to go through the court process and face their accuser in court or have somebody find out. I think that's a lot of the times they don't want their family to find out what happened to them, or their coworkers or bosses or those kind of things. They just don't want people to know. They're embarrassed by it when it's absolutely none of their fault that this happened to them. We're going to look at every case that we possibly can and follow it through as far as they want to. A victim can come in and make a report and work with us. We're not going to do anything that they don't want us to do. If they want to come in and just tell us the information just so that we have it for future cases, like I said before, if there is someone that's continuously perpetrating on people and they're afraid that it might happen to someone else. They don't want to necessarily have us go through an entire investigation or go through prosecution, but they want us to have that information. We're more than happy to do that. We'll stop our investigation or our process at any time that they want. We're not going to do anything that's going to make them feel uncomfortable. So if at any point they are, get nervous or scared, we can kind of back off a little bit. I would say, obviously, the sooner the better to come in and report. It's just easier for us to follow up on things, or if there would be some sort of physical evidence for us to collect, the sooner the better on that. But it's never too late. So anytime that you feel comfortable and you're ready to report that information to us, we'll be more than happy to take the report. Always just be aware of your surroundings, whether it's walking at night, just know where you're at, park in a well-lit area, or if it's out socializing with a group of people and maybe you're having drinks with someone, make sure you're the one that's getting that drink. Make sure you or know who it is and you trust that person so that someone's not putting something in there. And just always be aware of your surroundings, I think, is the best. As far as maybe parents with children, make sure that you trust the people that you leave your kids with and listen to them. If they tell you something, make sure you listen to them and you give them the support that they need once they're telling you the information that you might not want to hear, but just give them that support and let them know that they didn't do anything wrong. We have very little stranger rapes or stranger sexual assaults. It's almost always someone that someone knows, an acquaintance or a relative, if it being a child sexual assault. Usually it's always a relative, but even adults, it's usually an acquaintance or someone that they know or have previously dated or been in a relationship with. The police department responds on average to approximately 2 domestic violence incidents per day, which obviously is the majority of our calls for services that we go on. And we like to do a lot of training on this particular incidents because of the seriousness of it, for one, for the victims of the crimes, and then also officer safety for officers going and responding to those crimes. In 2013, we had 234 domestic violence and violational contact order related arrests. So that is another, basically not quite one a day that we're going for. So it's a lot that we deal with. About, I would say, almost half of those are the violational contact orders. So it's something that kind of alerts to us that a lot of these batterers or offenders are not stopping once we do get involved. They're still violating the law. They are going against what the judge is telling them to do and violating the no contact order. It's a mandatory arrest situation for us for violational contact orders. If the no contact order is violated, whether it's a civil protection order or a criminal order, the officer has to make an arrest on that no contact order and put the subject in jail until they see a judge. So they have to see a judge before they can be released. They can't just be released on their own with a police citation or something that other crimes could be done. The same goes for a domestic assault. That's a mandatory arrest if there's an injury that has occurred or strangulation or if a weapon has been used or threatened to be used. The officer has no choice whether the defendant wants them not to arrest them or the victim even tells them on scene, I don't want him arrested, just have them leave. We have to make that arrest. It's state law that we have to do that. So that person also has to go to jail or be seen by a judge before they can be released. Then there's also the no contact order would be put in place once that person is seen by the judge. We are concerned because of the increased number of homicides that happen from the domestic violence. We've had several already this year in Iowa. Luckily, we've not had any in Marshalltown, but there has been several already in Iowa this year. Both homicides and suicides together. Those just seem to be, there's been a lot of them already this year, like I said. We have several different people that work closely with domestic violence in our police department. Not only myself, but there are several officers that have gone to specific violence against women training as far as supervisors and patrol officers to help them respond to these situations, because it's a very, very delicate process. A lot of times we can get on the scene and you have both parties against you, or you're trying to help them out, and you just want to do everything that's possible. It's very hard, especially when there's children that could be involved. And that's another thing when we're on scene we have to think about. If that child was directly involved in that incident, there could be a child endangerment charge that could go along with it if that child was put in sort of harm or there was a risk of injury or death to that child during the incident. A child endangerment charge could go along with it, and then the Department of Human Services could also be involved with that family at that point. We're going to give that information to the victim for access services, so they have a victim advocate that would be at their disposal if needed. Shelter services are also offered to every victim that we deal with. And then if there is an arrest that's made, we give them information, what's called VINE. It's the Victim Information Everyday Notification, I believe. And that is given to every victim, and what they can do is they can sign up online so that that victim is notified when the offender is released from jail or moved to another facility. It's very instantaneous. Basically, once that offender is booked out of the system at the jail, it goes into a computer system, and that information is shot out within 15 minutes of that offender being released. So it's a very good notification for that victim to have.